urgent warning that got cut from a Supreme Court opinion 20 years ago is the headline on Richard Hanson's piece over at slate.com. It's an amazing story. It turns out it was Sandra Day O'Connor, who also worked to whip votes on the Supreme Court to make George W. Bush president in 2000. You know, it's, I think, a relative certainty that had Florida actually finished the recount that their state Supreme Court had mandated, that was stopped by the U.S. Supreme Court in violation, in my humble opinion, of the 10th Amendment. Not just my opinion, most court scholars, many court scholars anyway. But it was Sandra Day O'Connor who was whipping votes for that. And it was Sandra Day O'Connor who also put the kibosh on David Souter, warning Americans about what the court was up to, the conservatives on the court. Now, David Souter, again, was a Republican nominee. My recollection is it was George Herbert Walker Bush who put him on the court. I'm pretty sure I'm right. And this was more than 20 years ago. There was this case, Shrink, Missouri, in which he, in his dissent, he said, leave the perception of impropriety unanswered. And what he's talking about here is the Supreme Court's basically allowing political corruption. Now, this was before Citizens United, but this was after the Buckley decision in '76 and the Bellotti decision, First National Bank versus Bellotti in '78, where in Buckley the court said money in politics is the same thing as speech, and so you can't prohibit it. And in the Bellotti decision, they said corporations are the same thing as persons and entitled to rights under the First Amendment, including the right to free speech, which had 2 years earlier been defined as the right to pour money down politicians' throats. So in response to this, in a case tangentially associated with it, this is Shrink, Missouri, David Souter wrote, leave the perception of impropriety unanswered. In other words, if we continue to ignore political corruption, and the cynical assumption that large donors call the tune could jeopardize the willingness of voters to take place in democratic governance. Now, it turned out that David Souter actually wanted to go much farther than that, that he had actually, in his final decision, you know, he was trying to basically define corruption, but the problem was in the Buckley decision in '76, the Supreme Court explicitly defined political corruption as not including money being given to politicians, because money's speech now. So Souter had to figure out a way to say, this court, the conservatives on this court, are corrupting our political system in America in a way that's going to have very bad results as we go forward. And keep in mind, this was before billionaires were giving millions, tens of millions, over 100 million now in the last election cycle, individual billionaires over $100 million, to political candidates, political parties, and political issues. So what and we just learned this because John Paul Stevens' papers got released, and they included this correspondence between David Souter and all the other members of the court, but he was specifically having this essentially debate, you know, with Sandra Day O'Connor. And what he was, well, here's what he had to say. He said, there exists a broader threat that politicians will grow dependent on large contributions and will lose critical independence and instinctively identify interests of a plutocracy with the public good. Now, that was supposed to be part of his dissent in this, you know, Shrink, Missouri decision. But Sandra Day O'Connor was like, you know, you really don't want to say that. You don't want to say, you know, this is, you know, from the Buckley decision. The court ruled, quote, the concept that government may restrict the speech of some elements of our society, in other words, billionaires, in order to enhance the relative voice of others, in other words, average people, is wholly foreign to the First Amendment, which, you know, you and I understand is complete BS. There had been literally hundreds, perhaps thousands of laws passed at the federal and state level in the United States, largely dating from the 1870s, certainly in a large part, in a big way, dating from the 1890s. 1890 was when the Sherman Antitrust Act was passed. 1907, I believe, was when we got the Tillman Act, which made it a federal crime for any officer of any corporation to give any money on behalf of that corporation to any politician for federal office. I talked about this at some length yesterday. So we had all these laws on the books that restricted the ability of rich people to buy politicians simply because they were rich. The average person can't buy a politician. I don't have enough money to give enough, to give enough money to a politician that they're gonna call me up and ask my opinion on legislation, or that when I call them and offer my opinion, it's going to be consequential. But there's about 800 billionaires in America who certainly do. And there's, another couple thousand people who are worth hundreds of millions of dollars in America who can have that kind of impact. And the Supreme Court ruled, well, that's just fine. And when David Souter tried to come out and say, no, you're creating a plutocracy here, Sandra Day O'Connor talked him out of it. I think it's just incredible. She, in her note to him about his dissent, she said that his referring to plutocracy, quote, was unnecessarily sweeping definition of corruption, one which goes beyond Buckley's concern with quid pro quo corruption and the appearance thereof. She said, and then Souter responded to her saying, okay, I'll take it out. You drive a hard bargain. Now, that was in 2000. That was 23 years ago. And back then, like I said, we didn't have billionaires pouring money into politics the way we do now. We've got to do something about this. This is destroying our country. It's certainly destroying our politics, but it's also destroying our country.